Self-defense. When is it legal? When is it illegal? Thanks for joining us here today on the Fulgham Law Firm, our YouTube channel. Today I want to talk to you about self-defense laws in Texas. When are you allowed to act in self-defense, and when does the law say it's not sufficient and you can end up actually being charged with assault or worse? By the way, if you wait around to the end of our video, I'll also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Okay, every time we think about it, I run into people all the time that tell me, they come into my office and talk about, I've been charged with an assault case. I was just defending myself. Well, listen, self-defense is one of the most common defense strategies that can be used if you find yourself facing an assault or any type of assaultive-based offense, particularly in Texas. One of the most common ones, and this didn't happen in Texas, but one of the most common examples, or I should say notorious examples of this, was when George Zimmerman used it as a defense against the murder charge against Trayvon Martin. If you remember that, one of the things that he claimed that based on how he felt like he was being placed in fear of imminent serious bodily injury or death, and that was the primary argument by the defense on that particular case. So one of the things that we look at on this is you need to make sure you know what self-defense is. You need to make sure you know what Texas law says self-defense is and when it is appropriate to act in self-defense. Now, first of all, if you're going to talk about self-defense, let's first talk about assault. Because when you really look at it, you got to define what the offensive act is before you can determine if the defensive stance was appropriate. Now, you probably intuitively understand that what an assault looks like, right? Well, Texas law defines assault as any one of these reckless actions. If you intentionally or knowingly, and sometimes recklessly, depending on how it's alleged, cause bodily injury to another. Bodily injury, how do you define that? Well, that's just pain. If you intend to hit someone or contact someone in a way that causes them pain, that can be an assault. You can also intentionally or knowingly threaten another with imminent serious bodily injury or death. There you're talking about something like an aggravated assault by threat, particularly if you're using a weapon. Or you can intentionally or knowingly cause physical contact with another when the person knows or should reasonably believe that the other will regard the contact as offensive or provocative. That's known as assault by contact. That's actually a Class C misdemeanor, okay? Now, so how can self-defense work as a defense strategy for Texas assault crimes? Well, listen, if someone attacks you, ever since all the way back in time, all the way back to the very beginning, if someone comes at you, human nature is you're going to act for self-preservation. And you know, it's kind of a fundamental right. If someone else tries to come and attack you or take your life, you have a fundamental right, regardless of what government you're a part, what country you live in. You have a fundamental right to defend yourself from that imminent serious bodily injury or death. Now let's talk about the elements of self-defense in Texas. Now, how does a court determine whether or not a person acted reasonably in self-defense or not? They're going to look for the following elements. Number one, was there reasonable fear of bodily harm? Now notice, hone in on the word reasonable. If someone was just playing around with you and you attack them, then you probably won't be able to claim self-defense, okay? The situation before the assault, they're going to look at the exact situation before the assault and the surrounding circumstances and facts to determine if a reasonable person would have feared for their safety. So this is an example of the reasonable person standard being applied. Your subjective nature of things, when you look at that, one of the things is, does it make sense, right? Does any of this make sense? Now, another element that they're going to be looking at, and this is actually, I say, the courts, but it's really something that a jury would be looking at as well if you took your case to a jury trial, is imminent threat. That's number two. Was there an imminent threat? So if you felt that someone was placing you or another person in fear of imminent danger through a threatening force, some type of force that was threatening to you, and you believed it to be imminent, literally it was about to happen right then and there, then you may be able to justify your response as self-defense. Keep in mind, though, the following do not count. I'm going to give you a couple of examples of things that do not count as imminent threats. Offensive or provocative words that contain no threats, that is not an imminent threat. So if people just exchange words back and forth, right? If someone just says something to you and it's offensive or you're very upset by it, that is not going to be seen as an imminent threat on just those words alone. What about a threat that's been abandoned? What about someone that makes an immediate threat towards you, but then they retreat and they abandon that threat, and that threat no longer appears to be imminent? You can't claim that it's an ongoing imminent threat. That's one of the things that the courts and juries would look into in a particular situation of self-defense. So in other words, you cannot attack a person and claim self-defense if they threatened you, say, an hour prior, but you proceeded to calm down and not feel that you were at a threat anymore, right? Now, look, I know some of this seems like common sense, but one of the things you look at on this, I want you to understand, if the alleged victim assaults you, but then ceases to act towards you or threatens you, no longer threaten you, then it is not self-defense to then go back after them and attack them. So if they retreat from the engagement of the assault, you can't then go and beat them down claiming that it was self-defense, okay? So something else to know, it does not matter who the alleged victim of the threat is. You may be able to use self-defense for using force on someone who is threatening to hurt you or someone else. Additionally, if someone was threatening to attack your property, using force against them may be considered as self-defense. It's actually called a defense of property, right? However, you cannot use deadly force to protect your property in that situation. So this is important. That force needs to be proportionate, okay? The force that you use to act in self-defense must be proportionate to that. So if someone's coming and attacking, like tearing up your car or something, you can't walk up and shoot them in the head, right? I mean, that's not proportionate. They weren't threatening you directly. You do have a right to come and protect your property, but you don't have a right to use deadly force on someone who's just damaging property and not placing you in an imminent serious bodily injury or death in fear of that, okay? Now, so when we talk about proportional force, what does that mean? In order for an assault to be justified under Texas law, proportional force must be present. This means that the amount of force that's used to assault the alleged victim must be proportionate to the threats you received. I know this sounds like some sort of diagram or something that you're coming up with. No one's thinking about this at the moment of all these things taking place. So my point is this, though. The law is looking to see if you overreacted in a situation. So if someone walks up to you and they slap you on the face, you can't turn around and pull out a gun and shoot them in the chest. Okay? So, if someone comes at you trying to punch you, you don't get to knife them in the neck. It just doesn't work out that way. It's a totally different type of force. That is not a proportionate force. So finally, what about unprovoked attacks? Let's talk about an unprovoked attack. The attack from the alleged victim would have had to have also been unprovoked. This is an important element to look at. In fact, if you were issuing a threat towards the alleged victim, let's say you were threatening them first, you began to threaten them before they began to attack, they might actually be able to claim self-defense against you because you were the one that was initially provoking that attack, and maybe you were making threats towards them. So here's my point. Assault charges are very serious, and this applies to all types of assault charges, everything from a Class C misdemeanor assault by contact all the way up to an aggravated assault deadly weapon, or all the way up to a murder. You could be talking about a murder charge in this type of situation as well. So they're serious, and if deadly force is involved, it becomes even more serious. Prosecutors will usually try to fight you tooth and nail on this, and here's why. There's a victim involved. Okay. Anytime there is an alleged victim involved in a situation, prosecutor's going to feel a little bit more obligated to try to do all that they can to try to make you take a plea deal. But I want to remind you of something. If you and your attorney, your criminal attorney, decide to use self-defense as your primary argument, here's one of the benefits to that. If the facts present themselves favorably for you in that situation, it actually makes the burden of proving that what you did was not self-defense, that burden will go to the prosecutor. So now imagine this. You go to trial. It's going to require you, this is called an affirmative defense under the law. So an affirmative defense requires you to admit to the conduct. Yes, I punched him in the face. Yes, I shot the guy. I pulled out the gun and I shot at him. So you admit to the conduct, but you state that you had a specific affirmative reason, an affirmative defense as to why you did it. You only did it because you were acting out of self-defense. Now the burden shifts to that prosecutor to prove beyond a reasonable doubt that you did not act in self-defense. So literally, if your case were to go to a jury trial, that jury would be instructed by the judge. They, based upon all the evidence that they've heard, must conclude that the actions of the defendant were not self-defense. They would have to find a negative beyond a reasonable doubt. And by the way, that jury is going to have to make that decision unanimously. So on a felony case, that's 12 jurors all having to decide unanimously. And on a misdemeanor assault charge, you're talking about 6 jurors that would all have to decide unanimously, okay? And by the way, let's say your case is a pretty clear-cut case of self-defense. Your attorney can also, if it's a felony, make a presentation, do a evidence presentation to the grand jury through an evidentiary packet to show the grand jury clearly that your client, that in that situation, that your attorney can show that the client was actually acting in self-defense, and that grand jury may be able to get rid of your case quickly through a no bill. Okay? So it's important that you do not wait and hesitate if you know you acted in self-defense. Time is of the essence. There are certain things that can be done immediately to try to put you in the best place to be able to get rid of your assault-based offense, all right? So it's important to know there are always ways to fight back in this situation. In self-defense, any good criminal defense attorney is going to examine this as a possible element for a defense for your charge. And I just want you to know, if your case is in the North Texas area, we here at the Fulgham Law Firm will provide you a free case analysis and a free consultation. All you have to do is call our office at the Fulgham Law Firm at 817-877-3030. We would be happy to give you that free case analysis. And by the way, I promised you that free ebook. Click on the link down below. We'll send you over a free ebook, What to Do If You Have Been Charged with a Crime in Texas. I want to thank you for joining us here today, and we look forward to giving you more content on our YouTube channel, but I want to encourage you, you won't know about it unless you subscribe to the channel and like this video. Thanks again for joining us. We'll see you next time.